Good evening and welcome once again to the favorite show, The Law and You. This and every Tuesday at 8 p.m. on One Accord TV, One Accord YouTube, and One Accord on Facebook. Welcome as we join different panels of lawyers to come and bring you different topics on matters law. As you had spoken last week, we spoke about the Commander case whereby she had gone all the way to the Supreme Court. And from that places, as we had said, we'll be discussing things that are relevant and which are upcoming. There's been a lot of questions from the comments and from the emails that are running across your screen. And one question that has been coming up is, yes, we had recently a judge said there's no divorce by consent. And the biggest challenge people are having is, if I'm the one who decided to get married and I need to leave, why are you forcing me to stay somewhere that I need to leave? To come and discuss this and more, it is your favorite panelists that you have grown to love. Wakili, welcome. Give your people a name and where you work for gain.
My name is Ngugi, an advocate of the High Court of Kenya, and partner at Ngugi Muru Advocates LLP. We are located at Mbaabu building along Karen Road in Karen.
In Karen. Ukifika hapo kwa Deputy President Residence, hapo. On the other side, when you look on the other side, when you're on that side, that's where the offices are. Always your host, Kenneth Mbaabu from Mbaabu Advocates. We are situated at Muthaiga Square, and we are privileged today to be shooting and to be coming live from Muthaiga Square, from Mbaabu Advocates offices. We have spoken about a case filed by Coupler Attorneys and Consultancy, where they were the petitioners in a constitution petition division. And remember, we have been talking about divorce, and we have been telling people that divorce is, you go to the magistrate court. That's where you start your divorce process.
Yes.
But now here we are the Constitution and Human Rights Division. Maybe you can start by telling people how we found ourselves here and how is this not a person? Because this one is not a person. Coupler Attorneys and Consultants. It's more of like a company, an organization. And we know divorce, it is about a man and a woman. Tulijikuta hapi hapa organization iko kotini. And maybe to give people a broader view, it's Coupler Attorneys and Consultancy was the petitioner versus the Attorney General and the National Assembly, the first and second respondent. The Law Society of Kenya as a first interested party. We have Legal Aid Clinic as an interested party. In Africa, Isla Amicus and Federation of Women Lawyers FIDA Amicus as the second Amicus. So we are not finding names of John, James, Ken, Eliud versus Jane or initials JN versus yes. MN. Yeah. Why are we here? Why are we finding ourselves at the Constitutional Court?
The reason why they went to the Constitutional Court, which is part of the High Court, it's one of the divisions of the High Court, is because they were seeking clarification on a constitutional issue. And the High Court is the one court that has been given mandate and power to review and to deal with constitutional issues. And therefore, we could not have gone to the Magistrates Court or to the Court of Appeal or to the Supreme Court. We had to go to the High Court first and seek for this clarification on these issues to do with, I think, a marriage, the Marriage Act of 2014, yes.
And maybe as you continue, this is a petition number E075 of 2022, and the petitioner, the executive director, Akusala A. Boniface, I think is our wakili that I know. Maybe next time he should be here and tell us what was his thoughts, because for us we are discussing the case as it was, but we'd love to know what made him. Was it a reason why people had requested him? Because the issue of marriage, I think the biggest challenge is because marriage is, we touch on God. The Christians and maybe even Muslims and Hindus consider marriage was an institution started by God at the Garden of Eden. And we are, people when come, we say, the Bible talks about when you join two people, nothing should put them aside until death. And until death happens. And now here we are having the the petitioners going to court, and they want first the court to declare the Marriage Act contravening the provisions of the Constitution, and thus is unconstitutional. Second one was a declaratory order that parties to a marriage are at liberty to terminate their marriage by consent of parties thereto, and upon filing their consent in court, a decree shall issue to be filed with the Registrar of Marriage, and the marriage shall be deemed to be dissolved. Mandatory injunction also to issue against the second respondent, who was the National Assembly, to change the Matrimonial Causes Act and the Marriage Act to enable parties to a marriage of whichever regime to terminate marriage by consent. Maybe ili uweze kuelewa what we are talking about, they had gone to court first of the things first to say, watu wawili wakiketi, asubuhi ukiamka wewe na bibi yako, msikie mmechoka. Unatafuta karatasi pale, mnaandikiana, mnaenda kwa wakili, mnaandika, mnaenda kotini, mnafile. And with that, we are done. The same way, tulikuja sisi wawili, tukakura, tukaita watu mchele, wakasaini pa karatasi, tukasema tumeoana. Mbona atupatiwi ruhusa ya kufanya hivyo? Number 2, the issue was, can the court go and also, because you remember, and I'll mention, maybe, let me, so that we can all be on the same page, the Marriage Act in 2014, kulikuwa na a lot of acts. It came and collapsed, and the Marriage Act provided instances when people can dissolve their marriage, and this was it. One, adultery committed by a party to the marriage. Mtu akigongo ama na si mayai na si mlango, uko na ruhusa ya kumwachane. Cruelty, whether mental or physical, inflicted by the other party. If someone has been very abusive, either physically or mentally. Desertion by either party for at least 3 years. If someone has disappeared from yourself for 3 years, unaweza kuja continue useme iliisha. Then exceptional depravity by the other party. Ukinyimwa sana. Si kunyimwa tu, ukinyimwa sana. And then number E, the irretrievable breakdown of marriage, which among others include spouse willful neglecting the other spouse for at least 2 years. So we have these 1, 2, 3, 4, 5 things. That the Marriage Act provides, if these things happen, you can file for divorce. But now here the petitioner is going, and now I want your personal views before we go to the law. He's going to court and saying we should add number 6 to say, if people agree, let them leave each other. What are your personal, or let's call it personal Christian views on that?
Well,
before we go to what the court decided.
You know, my personal views are also informed by my Christian views.
Yeah.
And in my Christian views, one, a marriage is very solemn.
Yeah.
It's something that should not be taken, like Paul says.
Yeah.
It should not just be taken as a joke. And he even says, if you're not sure,
do not
get into it.
Yeah.
He even says it's better to be single, unless you're burning.
Yeah.
And so that informs how important this is. And therefore, to then say that I can easily walk in and easily walk out, first of all, I don't think you easily walk into this thing.
Yeah.
It's a long process. That involves animals. That involves people, that involves
there's a friend of mine who makes a joke that you waste, you get 4 weekends from people. You go for introduction, you go for Roragio, you go for Itara, you go for the wedding day, and you have carried a lot of people together. So I think saying you have walked in easily is not an easy thing, because even if you are going for the registrar at the AG's place, so utahitaji kwenda the first day, you go fill a form, come back, go another day, fill another form, come back, until when the day now for going to sign that marriage.
You even spend money.
Yeah, and you spend money. And in fact, another thing, and I don't know, maybe that's another thing maybe we should have a discussion on, is even normal contracts. For other businesses, if you are doing like if I'm selling to you land today and we enter into a contract, I cannot just wake up one morning and decide I'm not fulfilling that contract. So I think from now, our views based on upbringing Christianity is also saying marriage is sacred. If you walk in, you should think about it walking in, so that you don't walk out whenever you feel like you want to walk out. Now, when they went to court, and that's one thing you come to realize when it comes to constitution matters. In fact, sometimes you don't go to court. You don't go physically, kukura bibiria, tunasema kuapishwa. You go there, do your submissions, and the court decides, makes a decision. And this is what they did. The different parties wakafanya submissions, did their replying affidavits, and the court made a decision. And maybe that's what I want us to discuss. What did the court decide? Because there's a lot of confusion out there. Are we saying now that people can be able to finalize marriage?
Before we even get to what the court decided, I think it's important to also highlight what the petitioners were trying to say.
Yes.
One of the things they were saying is under Section 3 of the Marriage Act, it provides that marriage is voluntary.
Yes.
Between two adults. And so if it is voluntary, then you are using that same argument to say it should also be voluntary for the same two people to
when you think about it, it's true.
Yes, it is, but in most cases, kuna watu wataki kuachika. And that's there are people who refuse, and that's why we end up even spending a lot of time in court, because one is saying, no, not really. You've not given me a chance to express myself or to apologize. Makosa hufanyika sometimes, but don't just leave me. And so we were saying that provision by itself, now with what you have mentioned under Part X on the grounds, that the same way it provides that it is voluntary, then let's allow the same thing to happen. But then we had the respondents answering this, because there's already a bill. The Marriage Act amendment bill is in Parliament currently. I think it's by Honorable Peter Kaluma, who is trying to, the same issue, trying to have the same, go through the motions of legislation by the body that is responsible to make laws in this country, which is Parliament.
Parliament is National
and so,
Assembly.
National Assembly. And so the respondent were trying to say, because the National Assembly is also dealing with the same issue, there's something called separation of powers.
Separation of powers, yes.
Let's allow this body to finalize and deal with that issue. Number two, the court's work is not to make law. There's a body mandated to make the law. So this case should fail for those grounds. And so the arguments were made in court, and upon
before maybe we go there, I think there's something you've mentioned about the separation of powers, and I think we need to have a clarity on this. When they went, if you remember, one of the prayers we were asking is that they were asking, can the court command Parliament? Can you enact law? And the court at one point said, our work is not to command Parliament, because Parliament is an independent body. The only thing we can do is stop them if they are doing something unconstitutional, which I think it was a very well reasoned decision by the court, because if we do that, what will happen is that every now and then tutakuwa na mtu ameenda kotini anaambia County Assembly of Kiambu, County Assembly of Nyamira, can you do this?
Yes.
But the question, because laws are supposed to be done by people through consultation, unless the only time the court enters is when wakitoka inje, if they are not adhering to the constitution and everything. But there's another issue the petitioners were talking, and they were saying the biggest challenge with all the things we have mentioned, in Kenya the divorce process is a fault-based system. You go to court and say huyu hajafanya. And they were arguing and they were saying, like England and Australia, now they have come to no fault system. Si lazima umefanya makosa, ni hati sitaki kuendelea kwa hii ndoa. And I'm thinking about it, and I'm like, our forefathers would shatter on that. You cannot be given a reason, no fault. And they were saying, for example, like the countries in Canada, Hong Kong, and Germany allow the operation of both systems, whereby you can go to court, say huyu hajafanya, and still go to court and say tumechoka, wacha tuende, ama hatujachoka, ni ati mapenzi imeisha. So I think that's the thing that we need also to understand. They wanted us to move from a place, because the argument was very proper when you think about it, because we were saying sometimes you go, the children of in this marriage will come and read these documents in court, that father alisema madhe alifanya hivi, madhe alisema father alifanya hivi. So what they were saying, can we move to a place whereby it's by consent, this thing is not working, let us leave.
Yes.
So, but now, what did the court eventually decide on that? So because now those were the things that they were fighting about.
Even as they were fighting, something came out, and this is under the Constitution.
Yeah.
And I think the court mentioned this in the judgment and said, under Article 45, the Constitution of Kenya recognizes the family unit as a very fundamental part of a society. That when we talk about families in Kenya, the laws of Kenya recognize this to be very important, fundamental, and so you cannot just make laws that are going to affect this family unit. And so they went ahead in their decision to say that because of this provision that the family unit is very important. Number two, that we have the judgment, this is what I'm referring to, the judgment mentioned that they did not find any fault, and in that argument they came to reason out that they have provided a particular provision under the same Part X where we call it irreconcilable differences or irretrievable breakdown of a marriage, which is a ground that is closer to what they were trying to say. That you are not mandated to prove much. All you need to say is that the marriage is not working. And by just declaring that in court, then the court will allow you to leave. But they would not allow the consent judgment.
In fact, you have said something. The court said this. The society's interest in marriage is to ensure their success and not their failure, as it considers that marriage is the basis of the stability of the family, which is in turn the foundation of the social order. This can be confirmed by the fact that the Constitution recognition marriage is provided for under the Family Protection Clause. Number 73 was saying the society intervention to safeguard marriage is therefore seen through the law that regulates marriage. And what the court was saying is, if the people wanted to have walk-in, walk-out, they would have said that in the Constitution and in the Marriage Act of 2014.
And so irretrievable breakdown on marriages then becomes one of the grounds that one can use, that parties could use if that they're not able to continue with their marriage. And it's an easier option, it's a simple option that they can file. But even beyond this, for any viewer who is watching this, you know, you don't have to wash your dirty linen in public. If the marriage has not worked, or if the two of you have agreed, because we don't have now these consent divorces, but if you have consented to go separate ways in your marriage, all you need to do is just have one of you file, and the other person can
keep quiet and wait.
Can keep quiet, and then the matter can proceed undefended. And it will be faster, it will not allow you to wash your dirty linen in public.
I think that is what, because the court, basically that's what the court was saying, because what the court was saying, the provisions that are there in place, and if we need to increase those provisions, we can go through parliament. And this is what Wakila said. I think we have talked about this when we were talking about divorce, the processes, because when you get the decree, and in fact that's the reason why when you finish your marriage, you get a decree nisi. But still the marriage is not yet dissolved completely until you get the decree nisi absolute. The reason is because sheria inaelewa pia. Unaweza tokuwa umetoka asubuhi umekasirikiana na mzee na uka divorce, lakini jioni ukirudi unamuona, unakumbuka, unasikia ile shwa unakumbuka kwamba unampenda. So and that's the reason why the court was saying that sometimes temperature, we know of stories of people who have been divorced for 4 or 5 years and now they are married again officially again for 4 or 5 years. So, and I think everyone in marriage, and I think this is what we said the last Tuesday we talked about, is we talked about people need to talk to people, because a lot of people leave their marriage every day, and every day you go back to that house and you're like, watch nirudi. But in real sense, if it's up to you, a lot of people would have left marriage. And if now we start talking about this consent, unaweza andika umeandika consent ukaisend siku moja, siku nyingine ukuje inafailiwa. So I think that's what the court was saying. And what the court said maybe in summary, remember there was a prayer about the constitutionality of the Marriage Act. The court said that was not unconstitutional. The issue about can you force Parliament to do the law, the court said we cannot enter into a place whereby, because of separation of powers, you cannot direct Parliament what to do. And the last one, to specifically compel to amend and include a specific provision on that. The court said there's a process ongoing there. Let you go there, consider on the bill, and this is for all Kenyans. Let's be awake. These bills are being done. So tomorrow utasikia there's another clause here and there, and then utasema hey, mulibadilisha lini? Because when you are called to give your opinions, you don't give your opinion. This is an interesting case. This was a petition number 75 of 2022, which was dismissed with no order and to cost. This was done on 24th day of April 2025. See, this is the other day, and we don't know if they'll be going to the Court of Appeal to enrich to enrich jurisprudence.
Jurisprudence, yes.
And maybe before that, we'll be getting to our show, Akusala, to be able to tell us what is the reasoning behind this petition as they were coming. Wakili, any final words on the issues of marriage and on consent, on irretrievable breakdown, on divorce, and on walking in and walking out, and even on contract? Because remember, there are people now who are saying like Majuni contracts. Is that where we are going to? Andikiane 5 years, renewable. Ikifika si renewable, tunashuka. All these things that are coming up, what would you say?
Probably there are people who could say that there are changes in the world today. I think maybe because of the access to information compared to before. For example, the number of divorces are now higher than they were before, maybe also because of our lifestyles. But it's important to note that even beyond all these things around us, there's still marriages which are working. There are people who are allowing death to do their part. There's still, and then there are other factors that one needs to understand. There are seasons also that maybe me and my spouse may not be in this. We may be in a season where maybe because of other factors like economic, kasongo, those issues that may just affect. Yes, they may just be a season that will pass within 1 or 2 years, or even 5 years, or even 10 years, and later on we may have another season that will be amazing, blissful, where tunaangaliana tu like young people, like the first time I met her. And so it's also important to know that those seasons, they are, and we need to fight the welfare, spiritually. There are spiritual factors also to be fought. And so beyond all those things, then I believe the marriage, the family unit is very core and very important to our society. We cannot do much as a society without the family unit. And we need to keep protecting it. We need to look out for these bills. If you're able to peruse that current bill and you see that memoranda calling people to go and share their views, write those emails and send those letters to Parliament and tell them not to change the law.
Asante sana Wakili, as we are saying, there are a lot of new things that are coming in place, but also if you check what is happening in the world today, at the end of the day, a stable family ensures a stable nation for all of us. And especially now when you come back to Christianity, the Bible talks about work on your Christianity with fear and trembling. I want to believe they should have said work on your marriage with fear and trembling, because you have to choose each other every day. Ladies and gentlemen, it has been your favorite show, The Law and You, at One Accord. I've been your host, Kenneth Mbaabu from Mbaabu Advocates, and my guest, Eliud Ngugi from Ngugi Boro Advocates, LLP. Good night. God bless you.